Welcome to Case by Case. This is a podcast brought to you by Luke Zadkovich and Callum Chain of Zeiler Floyd Zadkovich. How are you, Callum?
I'm very good, thank you, Luke. I'm excited that once again we have a guest on.
Another guest.
Another guest.
Guests. Yeah, I'm always excited to have another guest on, particularly one as illustrious and esteemed as our colleague Aiden Lerc. You've plucked out a gem, I think, to talk about today, Aiden. But before we get into that, just a very quick introduction. Aiden's one of our associates at Zeiler Floyd Zadkovich, based in London. He's currently undertaking a PhD at Oxford, which is taking up most of his time, and working with us in a part-time capacity here and there. So yeah, welcome, Aiden. We're really pleased that you could join us for the podcast today, and I'm sure it's going to be an interesting one for our listeners. So the case that we're talking about today is a relatively recent Supreme Court decision of the United Kingdom. The judgment is called Tinkler and HMRC, and it had presiding on this decision Lord Hodge, Deputy President Lord Briggs, Lady Arden, Lord Burrows and Lady Rose, giving judgment on the 30th of July 2021, having heard the matter for 2 days in May. And just as a very short introduction on the topic, we're here to talk about estoppel by convention. And we will be looking at in the context of the HMRC and a taxpayer, where the taxpayer is looking to take, I think it's fair to say, a technicality here. And the question is whether through the conduct of the taxpayer and the taxpayer's accountants in particular, whether they should be stopped from taking a technical point. And we'll get into that in quite a bit of detail, I suspect, today. But we're focusing on estoppel by convention, and in particular, estoppel by convention in a scenario of non-contractual dealings. So, yeah, with that as a starting point, Callum, did you have any opening remarks?
So there's an interesting point in this, and I may be jumping the gun, but I thought it goes to the bench that we're deciding this case. One of the leading cases on estoppel by convention is a case called the bench. Well, there's the bench dollar case, and it's HMRC. It's our HMRC case. It's a great name for a benchmark case surrounding dollar bills. It's a great name. But even better was that the judge in that case in the High Court, I think, was Justice Briggs, who 10 years later or so finds himself on the Supreme Court, then deciding this case. And he doesn't give the leading judgment, but he does add at the end of the decision, he adds his own judgment, saying it's effectively, well, seeing as we're all going off the basis of my previous decision, I should probably supplement it a little bit now that I'm sitting in the Supreme Court.
I like that. Yeah, absolutely. And it's really the bench dollar with one minor amendment from the Blinley Heath case. But yeah, isn't it amazing how these justices and now Lord go through the system and then get into this kind of situation where other lords or ladies sitting next to them are making decisions on cases or relying on cases that they had already decided previously, which in this case was a happy consideration because they went along with the principles in the bench dollar. But you can imagine other cases where they may go the other way.
Exactly. No pressure to get it right. The decision is sat next to you.
Exactly. Well, look, let's get into it. I was thinking, Aiden, would you like to give us a summary of, and our listeners, a summary of the facts of this one?
Yeah, absolutely. I'm happy to kick it off. So essentially, I thought I'd start off just by saying that, well, what actually is the doctrine of estoppel by convention? So the doctrine essentially operates to prevent a party going back on an assumption that has been shared with and acted by the other party when it's unconscionable to do so. So the appeal in this case presented the Supreme Court with the opportunity to clarify the requirements for estoppel by convention. So in the case, the taxpayer, Mr. Tinkler, and his tax advisors were the respondents. And essentially under certain sections of the Taxes Management Act, the HMRC, so Her Majesty's Revenue Commission, must give notice of an inquiry into a taxpayer's tax return by sending a notice addressed to the taxpayer's usual or last known place of residence or their place of business. So
Aiden, tax inquiry, that is, we've got your return, we're looking into it, we've got some queries, and we're triggering like a formal inquiry process.
Yep, exactly. Yep, that's right. So essentially the HMRC sent a letter to Mr. Tinkler that was copied to his tax advisors, notifying him that they were conducting an inquiry into his tax returns in 2003 and 2004. But unfortunately for HMRC, the letter was mistakenly sent to a previous address of Mr. Tinkler and wasn't forwarded to him, so he actually never received the letter. However, his tax agents did receive the letter, and they responded to HMRC, essentially saying that they confirmed that they could not amend the returns, but they disputed the amount of tax that was owed.
So they've not responded to say anything about the address at this stage, right? They're picking up on issues, substantive issues with the questions that have been raised by HMRC.
Yes, but they did state that they thought that the notice that was given to them was in accordance with the Taxes Management Act.
Okay.
So implicitly, they suggested that it was sent to the right address, but also mistakenly they did that.
Yeah, they mistakenly relied on the assumption that the tax inquiry was valid for the purposes of the Act.
Yeah, the notice had been sent to the right address. Yeah.
Yeah, exactly. Okay.
So that all happens in about 2005. And then in 2012, HMRC sends a closure notice to Mr. Tinkler saying that they've ended the inquiry and they've determined that he owes about £700,000. So at the trial, which is before a tribunal, Mr. Tinkler's main argument is that the closure notice was invalid because HMRC had failed to give him a valid notice of inquiry when they sent the letter to the wrong address. And essentially, HMRC's retort to that argument was that Mr. Tinkler should be prevented by estoppel by convention from relying on the non-receipt of the letter.
So we're in slightly foreign territory for us kind of shipping and commodities lawyers when we're in the realms of tax. But the process for the kind of appellate court system for tax, it seems to be already this decision is you have a kind of first tribunal and then an upper tribunal and then the Court of Appeal.
Yep, exactly.
And then in the first tribunal, there's a number of arguments aired, and they're talking about, you know, whether notice was actually given, whether the notice was properly given because it was also sent to Mr. Tinkler's auditors or his accountants, and those arguments kind of come out in the wash by the time we get to the Supreme Court.
Yes, that's right. So by the time we get to the Supreme Court, all they want to hear about is estoppel by convention.
Who would?
Because they're essentially,
and who wouldn't want to hear about anything but estoppel, like you mentioned.
Exactly, and it's never been heard in the Supreme Court. So,
but what's interesting is that it's another classic pendulum case, isn't it? It goes one way in the FTT, the first tier tribunal, then it swings back the other way in the upper tribunal, and then comes back before the Court of Appeal and swings back in favour of the taxpayer, Mr. Tinkler. And then I'm blowing open the result by saying this, but the pendulum swings back again.
It does. It's one of those where you clearly there are arguments on both sides, firstly, but I think also it perhaps underscores the importance of having Supreme Court authority on this doctrine.
Yeah. Yep.
So the first point that it comes up is maybe not the first point it comes up, but the first kind of reported, the first presentation of the arguments before one of the kind of highest courts in the country is at the Court of Appeal. And the Court of Appeal decision, it seems to me, was very focused on this idea that the mistake was caused by HMRC doing something wrong and then almost misrepresenting the position to the taxpayer. And in those circumstances, the court seemed to feel as though you can't rely on estoppel by convention, because if one of the parties, if the party that's seeking to rely on the estoppel is the one that actually misrepresented the facts, and then the other side kind of went along with those facts on the assurance given to them by the party later seeking to rely on estoppel, then that party relying on estoppel is perhaps not allowed to do so.
Yeah, exactly. And I think this is one of the key provisions or key paragraphs from that decision. It said, a striking factual feature of the present case in relation to the alleged estoppel by convention is that any shared mistaken assumption was induced by HMRC's misrepresentation. And it goes on to note that the letter was false and what have you. But it was really emphasized that because this came from the HMRC, they were the ones who sent it to the wrong address for Mr. Tinkler, then the letter that was sent to the tax advisors was not really addressed to them. It was a copy of what had been sent to Mr. Tinkler, and the statement in that letter was that the tax inquiry was validly opened. And so it was this misrepresentation which was false, which the Court of Appeal noted and really emphasised. And that then, as you say, Callum, came through in the question of unconscionability.
Exactly. In some ways, it's a slightly strange doctrine, this estoppel by convention. It's almost as though the court is saying, well, you've all been wrong about this thing for so long that the thing has actually become true. Your mistake is, you're basically held to the mistaken factual or legal landscape that you were mistakenly operating in.
Yeah, and I wonder whether it's worth just unpacking the doctrine a bit more. The Supreme Court, when they came to look at this point, they traversed through 6 leading cases prior to the bench dollar decision. Did you think it might be worth touching on any of those, Aiden or Callum?
I think the main case we should certainly touch on is the initial first instance decision given by Mr. Justice Briggs, who later became Lord Briggs in this decision.
That's the bench dollar one, right?
Yep.
Yeah. Okay, let's skip to the bench dollar decision, because that really summarises the principles, right, of estoppel by convention. And also, is it the bench dollar or the Brindley Heath case where we're dealing with a HMRC taxpayer situation? That's the bench dollar, right?
It's the bench dollar, yeah.
Yep.
Yeah, exactly. Yeah.
So Aiden, why don't you take us through the principles of estoppel by convention as set out by Justice Briggs as he was in the bench dollar
decision. So essentially he sets out 5 principles. So first, there must be a common assumption of fact or law made by the claimant and the defendant, and it must have been made by clear words or conduct that is said to cross the line between them, that they share that common assumption. So what's so interesting about this first element is that if both parties hold a subjective intention in their own minds that this assumption is true when it's not, that won't actually make out this first element. What has to occur is there must be a crossing of the line by some sort of act or communications that's objective, that proves that both parties knew about this common assumption and relied on it, if that makes sense.
So it's not enough to show that both parties had the same idea. You have to show that both parties were kind of exchanging correspondence almost on the basis of this incorrect fact or incorrect legal landscape that they thought they were contracting on or working in.
Yeah, exactly. So even if I could show that there was evidence that both parties internally were operating under this common assumption, that's not sufficient. There has to actually be those communications that cross the line between them that objectively prove that both held this common assumption. Right.
And that the cross the line, that language, that actually comes from the Stena Lyon case, which was a decision that came after the bench dollar, also again before Justice Briggs at the time. And that presented the opportunity to Justice Briggs to give that refinement, to talk about this concept of crossing the line.
Yes, exactly. And I think what they were concerned about in this, or what gave rise to this requirement, is that it's very difficult, because what this estoppel by convention is essentially doing is modifying the obligations of the parties. And if you say that a subjective intent in someone's mind can change an objective obligation, that's quite a difficult proposition to make and defend in English law, where there's no other convention or principle that would say that. So to keep the law coherent, I think Justice Briggs has added this kind of additional principle to make sure that it must be proven objectively that both parties held this common intention, and therefore that can objectively change the obligations that these parties have agreed to.
Yeah. And so it's creating the connection, right? Isn't it, between this mistaken assumption that it's not just that each party has it, but that there's almost been this communication of it or sharing of it between the parties.
Yep, exactly.
And then the next requirement is this assumption of responsibility. Where I think it's set out in the bench job that the expression of the common assumption by the party alleged to be estopped must be such that he may properly be said to have assumed some element of responsibility for it, in the sense of conveying to the other party an understanding that he expected the other party to rely upon it.
So this was probably the most contentious point of application in the decision, in that, could you say that because the tax agents had responded to the letter confirming that they believed that the HMRC's initial notice was in accordance with the Tax Management Act, did that mean that they assumed a level of responsibility for HMRC now relying on that common assumption? And it's interesting because it was a unanimous decision, this decision, and all of the lords essentially said, yes, that was sufficient.
Yeah.
Which to me is a very low bar.
I agree. I felt the same way, this assumption of responsibility without any kind of well, I guess they responded to the inquiry as though it was a valid notice. And I think they did note that it was a valid notice. But it's a stretch almost to say that you accept responsibility for somebody else's error by simply not checking thoroughly enough on whether or not they're correct in what they're asserting.
Yes. Yeah, I entirely agree. I mean, it's so difficult because, as you said, Callum, HMRC have made this mistake. The tax agents have relied on that mistake because HMRC made it in the first instance. And now it's coming back on the tax agents saying, well, because you also shared that common mistake, your obligations, well, you now can't rely on the fact that that notice was in fact not in accordance with the law. Because
I suppose one of the, not quite playing devil's advocate, but just thinking about it from the other perspective, part of the issue that you have kind of from a technicality type perspective is, well, surely the tax accountants were in the position of establishing whether this was sent to the right address or not. There was some authority. I know it was contended as to what their apparent or ostensible authority was, but at least at some level, Tinkler had previously said that these tax accountants would be acting for him as a taxpayer. And within that agency, it would have been possible, at least, for the accountants to find out what the correct address was. It's not like it was a mistake that was made in a way which was not verifiable or easy to verify. Now, whether the tax accountant should be, or indeed as agent for the taxpayer, put in the position of having to take that position, when that's not really what this letter was about, and that's not what the mistake went to. But you can see how it's not a difficult mistake to have picked up. And indeed, by going, the tax accountants could have said, if they had picked up on the point, they could have responded in a way which contained some kind of reservation as to the validity of the tax inquiry. I don't think they had to respond in a way where they took on this mistake.
Or ideally, they don't respond at all, and they let time elapse, and then they
exactly
say, "Yeah, we received all of your," or even simply say, "We've received this. We acknowledge receipt of this copy." We acknowledge receipt of a copy of this tax inquiry form. We're straying a little bit into one of the reasons, I think, why this decision went the way that it did, which was that they actually didn't know. The tax accountants proceeded on the basis that they'd received a valid notice, and they didn't realize this point where they might be able to unwind the whole thing and actually find that the taxpayer was able to get away with this until the eve of a couple of months before the decision was going to the first tribunal. And this, we're slightly jumping around in the order of the 6 principles in the bench dollar, but the 6th principle is the unconscionability provision. And I think that this kind of saves, in a way, not saves, but this helps with the 2nd principle. It helps make the 2nd principle more palatable, where the court will only the court will only find that there is a estoppel by convention in circumstances where it would be unconscionable for the party to turn around and seek to rely on the true factual position, having proceeded on the shared basis of the wrong factual position. And I think that test of unconscionability is therefore quite important in circumstances where it seems the bar is quite low for a party to assume responsibility for the incorrect facts.
See, I'm a bit skeptical of the term unconscionability, Callum. I mean, what does unconscionability really mean? Surely two people could reasonably disagree on these facts, that what the tax agents were doing were unconscionable, or someone might think, no, they weren't unconscionable. I mean, it has such a wide definition that to me, it's not particularly that helpful.
And the fact that I can see a point here, which is that is it really that unconscionable for someone to turn around and say, no, actually, you made a mistake a while ago. Sorry.
Yeah, I see your point.
I mean, I think I'm kind of agree with you in the sense I'm not seeing something which is totally unconscionable. I mean, if you put it to me, would my conscience be able to live with what Mr. Tinkler did here in turning around after the fact and saying, actually, it turns out that there was a mistake, and you're actually not entitled to do this tax review. I think actually your conscience would be fairly clear, turning around and saying it wasn't, it was your mistake. It's not my mistake. I'm not trying to take advantage of a mistake that I've made. I'm just saying that you failed to send the tax return to the right place, and therefore you can't bring this claim against me. I don't necessarily see a clear unconscionable element. I think it goes to the question of what is unconscionability. As you say, Aiden, it's a movable feast.
But I think that I'm with Aiden a bit on this because, and agree with you too, Callum, in that unconscionability it's almost like a concept of its own, right? It exists as a concept. We know it in other contexts, and as a principle tacked on to the 6 bench dollar principles, there is a danger that it could be given too much weight, and then you get into this almost like a judgment call, right, where you're then taking a view on whether the taxpayer should have spoken up and told the HMRC at an earlier point in time, when they knew they had actual knowledge of the tax inquiry, to say it was, it wasn't properly served, or whatever it was, or indeed whether they can sit back and rely on a technicality in matters of tax. And we know that there are plenty of technicalities, even from our standpoint in the areas that we focus on, guys, that technicalities are taken in tax law. Maybe it's one reason why we steer away from it. but you can see that the principle or the decision should not really be turning on, are we taking a view on the unconscionability or otherwise of this particular set of facts?
Yeah, I agree with you. I think that really what's future cases that are going to arise that concern this test are going to focus on the nature of the mistake and what was reasonable for the mistaken party to do in this instance. Should they have investigated further and explained the assumption that they were relying on, or was it reasonable for them just to continue to rely on it?
Yeah. I think I'd like to come back to this point on unconscionability, because I think it's interesting in the context of a argument of a counterclaim almost to a defense to a misrepresentation argument. But before we do, I think we should round off the 6 principles from the bench dollar, and maybe we just do that quickly by saying that the third principle is reliance, which we see across the spectrum of estoppels. the fourth principle is that the reliance has to have occurred in connection with a mutual dealing between the parties subsequent to the parties working on these incorrect facts. And then the fifth principle is that there must be some detriment. Those are kind of the six principles. I'm just conscious that we were getting fixated on the sixth, so I wanted just to go through 3, 4, and 5. But now we're back to 6 again. I'm going to get fixated on it again. Because
But do we need the 6? Well, do we need the 6 is the question, Callum.
Right. And I think that there's a point at the end of the leading judgment here where I think it's Lord Burroughs who gives the leading judgment in this one. He says, okay, well, there's a point to make here. There's a point to clarify, which is the relationship between misrepresentation, a claim of misrepresentation, and the unconscionability element of estoppel by convention. And the point that he makes is, if a party is bringing a claim in misrepresentation, then that claim relies essentially on the fact that one party misrepresented the factual picture to another, and both parties went along on that mistaken belief until they subsequently found out that the facts were wrong, and then the innocent party brings a claim of misrepresentation. And Lord Burroughs says, okay, well, there's a danger here, which is that someone might turn around, a defendant to a misrepresentation claim might turn around and say, well, as a defense, I bring up estoppel by convention because we actually both proceeded on the basis of my misrepresented set of facts. And having proceeded on the basis of my misrepresented set of facts, you can't now turn around and sue me for that because that would be to my detriment. And therefore, I'm going to defend your claim with estoppel by convention. So the estoppel by convention claim defends the misrepresentation claim. And Lord Burroughs says this is where you need the unconscionability element, because that's unconscionable, and unconscionability will protect the party who should benefit from the, in that case, misrepresentation claim, and it will prevent the party seeking to rely on estoppel when they're not entitled to.
Yeah, I see that. And again, we're presented with a stark example. It's easy to come out with that type of rationale. But when you're talking about the judgment call, the ones where you could argue it both ways, I think the unconscionability element does create some ambiguity in my view.
I agree. And so the alternative, perhaps, is then you look at the way the Court of Appeal dealt with the doctrine and the decision they came to, which was to say, you don't get to benefit on estoppel by convention. You don't get to benefit on this estoppel from this estoppel if you're the party that made the initial misrepresentation. To a point, that's putting a bit of a gloss on what the Court of Appeal said. But they were very interested in this fact that this was HMRC that made the misrepresentation. It was them that started this pattern of the facts being wrong. They were the ones that forwarded the tax notice as though it was a valid notice, and therefore they don't get to benefit on this doctrine of estoppel. The Supreme Court didn't go with that because one of the foundational cases for estoppel by convention expressly says that it doesn't matter whether it was a mistake or misrepresentation by the party later seeking to rely on the principle. But I wonder if that's a neater way around than having this kind of unconscionability at the back end.
See, I think you've also got to take into account that it was just such a basic mistake that was so easily able to be determined whether it had in fact been made or not by the tax agents.
And does that to you does that make it less unconscionable or more conscionable for the party to say no?
Well, no. What I'm saying is that HMRC have made a mistake, and now they're essentially relying on the tax agent's assumption of that mistake. But because the mistake that HMRC made was so small and so easily discoverable by the tax agents, it doesn't make sense that now the tax agents, because really they should have discovered that mistake, can now rely on that to their benefit when such a mistake really, in the scheme of things, wasn't a big one.
Yeah, so it's something that should have come out in the wash. If it was an issue, then it should have come out in the wash. I guess there's also a point here, which is it is a very technical point. I mean, what's the purpose of this provision that says that the notice has to be sent to the last known residence or place of business of the person? Well, it's clearly to make sure the person receives it. And if somebody confirms that they've received it, and then you proceed on the basis that they've received it, and you proceed on the basis that it's valid, then it's a highly technical argument.
I agree. And the fact that his tax agents told him that they had received a copy of this letter and they spoke with him about how they should proceed. I mean, it's just icing on the cake, really.
Yeah.
Yeah, I think there were elements of actual knowledge went against him. Having sophisticated accountants representing him went against him. A letter saying they had agency to represent him in some respect, and acknowledgement of the tax inquiry, and then the multiple messages and discussions that were then had after that initial acknowledgement of the tax inquiry copy letter that suggested there would be engagement with the tax inquiry. And you can see when you put that pattern of facts together that it's not difficult to see why the Supreme Court went the way that it went. Had the tax accountants not engaged in the way that they had, then I think the result may have been different. But that's where I've got the most difficulty, I suppose. Well, that's where I can sympathise with the decision or agree with the decision and where it ended up. But I just still have this kind of concern about that sixth element. In any event, I don't think that's what determined the case here. I don't think it turned on unconscionability. I think it turned on as you noted earlier, the responsibility point. This taking on of the assumption, not just acknowledging it, but, as you described, crossing the line, going further and then relying upon it and taking steps to suggest that it's been assumed, it's been taken on, and, we're moving forward on that basis.
That's a good point, Luke, because I think there's a point to be made that maybe what will satisfy the assumption of responsibility, that element, and what conduct amounts to an assumption may change depending on the nature of the mistake that's been made. And if the mistake is a small one, then it's easy to assume responsibility for the other party. But yeah, the other party's reliance on the common assumption.
Yeah, but it's also how you respond, right? So I think it's more than acknowledgement, isn't it? It's not just okay, we've both made the same mistake. I've taken on that mistake as well. It's got to be something more. And I think if I was looking at this case to then try and distinguish it from another set of facts, I would be honing in on, well, what was the response? How far did the next set of tax advisors go in acknowledging that tax inquiry? Were there reservations made? Were there, we need to look into this and conduct more investigations, but yes, we got your letter. That it would be that area of, crossing the line, assuming, taking on, subscribing to the mistake, where I think the future debates will be had.
I think there is, I agree with that. And I think there's also, to go back to Aiden's comment about the scope of the misrepresentation, or the scope of the thing, which is where the parties are proceeding on a kind of mistake. How big is the mistake? And in this case, it's quite a narrow mistake. There's a tax notice which has been received by the intended recipient, and the scope of the mistake is that it was sent to an older address rather than a new one. But it's quite narrow, that both parties have in a sense that both parties have assumed that both parties haven't assumed a wide-ranging, an entirely different fact pattern to reality. It's a pretty narrow difference in facts. In order to be valid, this notice had to be sent to address A. It was in fact sent to address B, and both parties are working on the mistaken assumption that it being sent to address B and then being forwarded to the tax accountants satisfies the notice requirements. And because it's so narrow, the kind of the mistaken facts, you perhaps need less to get yourself across the threshold of accepting responsibility for those facts.
Yeah, no, I agree, Callum. And I mean, let's not forget that Lord Burroughs explicitly states that these 6 principles apply not only to tax dealings, but also more widely to contractual dealings. So, I mean, and any considered obiter dicta is binding on the lower courts. So these 6 principles are now going to apply to all contractual dealings as well.
It's a good point. And you do see that, we're talking about a tax case here, but there are a number of shipping cases that make up the world of convention estoppel by convention.
Yeah.
It's a fascinating point when you think about that this has been looked at in the context of non-contractual dealings, but then overlay some contracts and other obligations and rights and responsibilities between the parties, and then bring this into the mix. I can't help but think, again, Callum and I, we've talked about this before, and I know you're aware too, Aiden, but doing these podcasts, it does make you start thinking about cases, facts as they come to you from clients, and in other situations, like, okay, mate, I could look at that case through the lens of estoppel by convention, or just understanding estoppels more generally through what we've talked about today. So look, I've really enjoyed the discussion, guys. Any other final comments before signing off on this one?
I'll just jump in to thank Aiden for joining us. He's, as Luke said at the start, he's in Oxford doing his PhD. I know that his PhD is on. Well, I'll leave him to say exactly what it's on, but I know it's in the world of torts. So us looking at a non-contractual estoppel, I know is right in his sweet spots. So we're very grateful for him to join us.
Thanks, Cal. No, I've really enjoyed it. And I mean, look, anything private law, I'll get around it. But my thesis is on injunctions in tort law.
There we go.
There you go. more on that topic coming to you from a podcast soon. All right, guys. Look, thanks again for your time. Thank you, listeners. I hope you found this episode interesting, giving you some food for thought on your cases or matters or business. If you'd like to discuss it more, please do get in touch with Aiden, Callum, or myself. We've enjoyed having you on. Thanks again for your patronage, and hope you can join us again next week. Another podcast will be coming out on Thursday. So keep subscribing, keep sending that feedback to us. It's all taken on board and greatly appreciated. Until next time, take care.